Welcome everyone to our presentation on Supervisors and Title I of the ADA. My name is Dustin Schwab and I am a Career Development Specialist here at Opportunities for Ohioans with Disabilities, which we refer to as OOD. Today I am co-hosting with my colleague Julie Wood.
Thank you, Dustin. Hi everyone. My name is Julie Wood and I am OOD's Worksite Accessibility Specialist. I'm also an occupational therapist and a certified ADA coordinator. One of my roles is to create presentations that support employers, including state agencies, in navigating their responsibilities under Title I of the Americans with Disabilities Act, which is the ADA, and fostering inclusive and accessible workplaces.
Thank you, Julie. Before we begin, I'd like to mention that accompanying today's training is a learner's guide and a helpful fact sheet. The information that we share in these resources and during today's conversation is for educational purposes only and is not legal advice, but we do hope this information is helpful for you. Julie, let's share the accessibility practices we have included in this webinar.
That's a great idea. When we create our training materials, we plan for accessibility up front. For example, we use the accessibility checker that is built into Microsoft 365 to review the accessibility of the learner's guide, fact sheet, and PowerPoint. We pay attention to color contrast, font size, and we make sure to add alternative text to any visual images in these materials. Also, in our delivery today, you will notice that Dustin and I mention each other by name as the conversation between us goes back and forth. We do this intentionally so the audience is aware of who is speaking. This can be helpful when attendees are receiving this information through services like American Sign Language interpretation and live captioning. And after recording the webinar, we edit the transcript and fix any captioning errors before publishing and delivering the webinar. Taking just a few intentional steps up front can make this presentation more accessible and inclusive for everyone.
Okay, Julie, this webinar addresses best practices for supervisors when it comes to hiring and managing employees with disabilities. Why is this topic so important?
Dustin, supervisors may not be as familiar with Title I as someone in human resources, but they can have a big impact on whether a qualified individual with a disability is hired for the job, remains on the job, advances at work, and feels included in the workplace. They can also impact whether an employer is adhering to its responsibilities under the law and help to foster a disability-inclusive culture. And that's because supervisors may assist with establishing qualification standards and essential functions, navigating the hiring process and part of the interactive process, identifying and facilitating reasonable accommodations, and managing common situations with employees when disability is a factor. Without training on Title I, supervisors may feel uncomfortable interviewing candidates and managing employees with disabilities. And when they don't know the right thing to do, they may not do anything because they don't want to do the wrong thing. So this training is designed to help supervisors feel more comfortable and empowered when addressing situations when disability is involved. Now, each agency may have its own expectations for the supervisor's role in handling disability-related situations, so it will be helpful for the supervisors to know these, including when to refer candidates and employees to HR.
You make some good points, Julie. I was a supervisor in a previous role, and I believe this type of training is helpful because supervisors want to do the right thing, but as you said, they don't always know what that is. And really, you supervise employees with disabilities the same way you supervise employees without disabilities. But we do want to acknowledge that when certain situations arise and disability is a factor, there are guidelines to follow under Title I. So these are important for supervisors to be aware of. Okay, let's begin with creating a disability inclusive culture. Julie, this really starts at the top of an organization, doesn't it?
Yes, the culture of an organization does start at the top. And so if you want to be intentional about creating a culture that is disability inclusive, the best practice is to get support from leadership. As state employees, we are fortunate to have this support already because Ohio is designated as a disability inclusion state and a model employer of individuals with disabilities. Because you are participating in this training that is specific to supervisors, It's apparent that leadership values the supervisor's role in following Title I and in creating an inclusive culture. This sets the stage to ensure supervisors know how to hire and manage individuals with disabilities in a way that supports them to be successful. One way to help supervisors foster a disability inclusive culture is to train them on disability awareness and disability etiquette. Dustin, you have delivered these trainings.
I have. OOD offers these at no cost for our employer partners, including state agencies, and they're intended to make everyone feel more comfortable and included at work. Our disability etiquette training defines disability, includes practical examples of respectful interactions with people with disabilities, and addresses proper language usage. We can provide this training in person or virtually, and we have an on-demand version available on our website. We also created disability etiquette and awareness training that is available for all state employees through Ohio Learn, which some agencies use as part of their onboarding training for all new employees and new supervisors. So providing disability etiquette and awareness education is a great first step. Another step to consider is how your job's qualification standards and essential functions play a part in creating an inclusive workforce. Julie, can you tell us how supervisors may be involved with these?
Sure, let's start with qualification standards. These are the requirements for the job, like education, experience, licenses, and skills. They're intended to predict or measure a person's ability to perform a certain job. Supervisors may be asked for their input on a job's qualification standards, so it's important to note these must be job-related and consistent with business necessity when they are applied to individuals with disabilities. Now, this is a phrase used often throughout Title I, and generally, job-related means a standard applies to a specific job, not to a general class of jobs. And consistent with business necessity means a standard applies to the essential functions of a specific job. So knowing this helps a supervisor to be aware of the importance of making sure qualification standards are written accurately. And that includes making sure they are written in a way that does not limit how an individual can meet the standard, because these can often be met in more than one way. I have an example that shows how a qualification standard may be written in a discriminatory way and how to correct it. Let's say a job requires an employee to have a driver's license to perform the essential function of attending meetings in the public. If a person can't drive because of their disability, this requirement could be considered discriminatory. When reviewing this qualification standard through an inclusive lens, consider what other ways this essential function could be performed. Instead of driving, the employee could use public transportation to travel to the meeting. So a more inclusive way to write this standard is to require the employee to travel, but not require them to drive to attend the meeting in person.
Thank you, Julie. How are supervisors involved with the job's essential functions?
Justin, the essential functions of a job are the main work tasks and critical duties of the job. Because supervisors may be asked for their input, it's important to know how these apply to individuals with disabilities. Title I requires qualified individuals with disabilities to be able to perform the job's essential functions, with or without a reasonable accommodation. It's helpful to be aware that an essential function can often be performed in more than one way, just as effectively using a reasonable accommodation. And so it's a best practice to write essential functions based on the expected outcome of the task instead of on how the task is performed. For example, instead of stating an essential function is the ability to talk and hear over the phone, state the essential function is to communicate with customers over the phone to exchange information. An individual with a hearing disability may achieve the outcome of this essential function in another way, just as effectively, by using a phone with captioning or a video relay service.
That's great information, Julie, because employers hire qualified individuals to achieve outcomes, not to perform tasks in a certain way. This is a great segue to our next topic, which is the hiring process. So supervisors often have a role in identifying, interviewing, and selecting qualified candidates for open positions. So it's important for supervisors to know the ADA guidelines for the hiring process and the ways they can contribute to making this process disability inclusive. This helps supervisors to feel more comfortable and prepared to handle situations that can arise when a candidate has a disability. To support this, we are going to discuss how the ADA defines disability, how qualification standards and essential functions apply to the hiring process, and then address the two phases of the pre-employment process regarding asking questions and administering exams. Julie, what is the ADA's definition of disability? I know it's a legal definition and not a medical one.
That's right, and it can differ from how other laws define disability. The ADA's definition has three parts. The first defines disability as a person who has a physical or mental impairment that substantially limits one or more major life activities. The second defines disability as a person who has a record of such an impairment. And the third defines disability as a person who is regarded as having such an impairment. So based on these definitions, people with disabilities are protected from employment discrimination, but so are people without disabilities when they are perceived by others to have a disability. This is important to know because while it might not be intentional, hiring professionals sometimes take discriminatory actions when they make decisions based on things like stereotypes, unfounded fears, or things that simply are not true about disability. Or they make assumptions that a person with a disability is unsafe or won't be able to perform the job or will need an accommodation that costs a lot of money. So to prevent this, training is helpful. Disability awareness education can help minimize these actions and support a disability inclusive hiring process by making supervisors aware of any personal biases they have towards individuals with disabilities and helping them to feel more comfortable when conducting an interview. This can also help a supervisor to understand that behaviors they may notice during an interview, like a flat affect or decreased eye contact, can be related to a disability and doesn't mean an applicant isn't interested in the job or engaged with the interviewer.
That's a great example of another way that disability awareness education can be beneficial. Now, let's discuss how qualification standards and essential functions can support disability inclusive hiring processes and help to identify qualified candidates for the job.
Justin, as we said earlier, qualification standards are often used to predict a candidate's ability to perform the job. And so a supervisor may decide whether a candidate meets these standards before they determine whether they can perform the essential functions. So it's important to know what the ADA says about qualification standards and disability. The guidance from the Equal Employment Opportunity Commission, or EEOC, says when a qualification standard screens out a candidate with a disability, the standard must be job-related and consistent with business necessity, which means the standard relates to the specific job and its essential functions. The guidance continues to say that when the standard is job-related and consistent with business necessity, the employer must consider whether there is a reasonable accommodation that enables a candidate with a disability to meet the standard. Certainly, making the wrong decision here could result in a legal liability, and while that's important, I also want to note that this decision could result in overlooking hiring a qualified candidate for the job. I have an example to help illustrate this. A supervisor is interviewing a candidate for a job with a qualification standard that requires the ability to lift 50 pounds. During the interview, the candidate discloses a physical disability that prevents him from lifting more than 25 pounds. So the supervisor decides the candidate is not qualified. If the qualification standard is not job-related and consistent with business necessity, then it would be unlawful to use the standard to screen out the candidate with a disability. If it is job-related and consistent with business necessity, then reasonable accommodation must be considered, which could include providing a lifting device or permitting this task to be a two-person lift. Again, if reasonable accommodation isn't considered, there is a risk of a legal situation and also the possibility of missing out on hiring a qualified candidate. So to avoid this, it's important to know how to recognize when a qualification standard is or is not job-related and consistent with business necessity, and when reasonable accommodation must be considered.
That's helpful. Julie, what is important for supervisors to know about a job's essential functions when it comes to the hiring process?
Under Title I, individuals with disabilities are expected to be qualified for the job, which means they can perform the job's essential functions with or without a reasonable accommodation. Now, being qualified does not require an individual with a disability to be able to perform the job's less critical duties, known as marginal functions, and that's because one type of reasonable accommodation is to eliminate or swap marginal functions. An employer does not have to eliminate an essential function as a form of reasonable accommodation, but they do have to consider whether a reasonable accommodation exists to enable the individual to perform the job just as effectively in another way. Sometimes we get stuck thinking there is only one way to do something because that's how it's always been done, or because we don't know what we don't know and we can't imagine how else to do the job. So remember with essential functions to focus on the ability to achieve the outcome of the task instead of on the ability to perform the task the way it's always been done. We are going to discuss what you can ask and when during an interview to get to the information you need to decide whether a candidate is qualified to perform these tasks.
Great. So once a candidate is identified, the pre-employment phase begins, which includes interviewing, testing, making an offer, and conducting any medical inquiries and examinations. Pre-employment is divided into two phases, pre-offer and post-offer. And the EEOC has distinct guidance on what can be asked in each phase and regarding what you can ask when you know a candidate has a disability.
That's correct, Dustin. What's important to remember is that hiring professionals are permitted to ask questions of candidates to assess whether they're qualified for the job. There are just certain rules for what can be asked and when.
Okay, Julie, let's start with the pre-offer phase.
In this phase, disability-related questions and medical exams are not permitted. This is to make sure all candidates are evaluated on their ability to do the job without consideration of disability. So in this phase, a best practice is to focus on the candidate's ability to do the job by asking about the candidate's ability to perform the essential functions. One way to support this is to have questions pre-written for the supervisor to ask. I have some examples of what you can ask in the pre-offer phase. You can ask about the ability to meet the qualification standards. You can ask about the ability to perform the essential functions, as long as they are not phrased in terms of disability. For example, instead of asking a candidate if they can lift 25 pounds, describe the job task, like moving 25-pound boxes from a skid to a cart that is 36 inches high, and ask the candidate if they can perform this task. If you simply ask if a candidate can lift 25 pounds, the question may elicit a response that reveals a disability. But if you describe the outcome of the task, a candidate with a disability will know if they can perform this essential function with or without a reasonable accommodation. And you can ask all candidates to describe or demonstrate how they would perform a job task with or without reasonable accommodation.
Julie, does any of this guidance change when a candidate has a known disability?
That's a great question. Sometimes an interviewer knows a candidate has a disability because the disability is obvious, like a candidate who uses a wheelchair, or when a candidate chooses to disclose an invisible disability, like dyslexia. What the guidance says is, when you know a candidate has a disability and you can reasonably believe the disability may interfere with or prevent the candidate from performing a task, you can ask the candidate to describe or demonstrate how they would perform the task, even if you did not ask the other candidates. For example, if you are interviewing a candidate who has one arm for a job which requires moving bulky items from the ground to shelves that range in height up to 6 feet, you can ask the candidate to describe or demonstrate how they would perform this task with or without a reasonable accommodation. Just make sure the question is not phrased in terms of disability and is focused on performing the job task. I know this can be uncomfortable because no one wants to do something wrong by asking a question, but think about it this way. If you don't ask, are you really giving the candidate an equal opportunity to compete for the job? If you don't ask, are you assuming the candidate cannot perform the task? If you don't ask, will the candidate think you are not giving them serious consideration as a qualified candidate? When you ask, if the candidate says they can perform the task with a reasonable accommodation, then either provide the accommodation so the candidate can demonstrate the task, or allow the candidate to describe how they would perform the task. As we said earlier, it's important to remember the outcome of a task can often be performed in more than one way, just as effectively. Even if you as the interviewer are not familiar with another way to perform the task, the candidate you are interviewing may know exactly how they can do the job in another way. So give them the opportunity to tell you. Now, if a candidate has a known disability that would not reasonably interfere with performing a task, then you can only ask the candidate to describe or demonstrate how they would perform the task if all candidates were also asked to do this.
Great points, Julie. So in the pre-offer phase, the employer is asking job-related questions to determine the candidate is qualified. What is the post-offer phase and how do things change?
Dustin, a candidate enters the post-offer phase once they have accepted the formal job offer, but before employment begins. In this phase, disability-related questions can be asked and medical exams can be required. The key here is these must apply to all candidates who receive a job offer in the same job category. Now, the job offer can be conditioned on the results of these questions and exams. However, if these results lead to not hiring a candidate with a disability, this decision must be job-related and consistent with business necessity. If the candidate is screened out due to a safety concern, the employer must demonstrate direct threat, and there are specific criteria to follow to make this determination. In either case, reasonable accommodation must be considered to discover if an effective solution exists to enable the candidate to perform the job effectively, and in the case of direct threat, to eliminate or reduce the threat to an acceptable level.
Thank you, Julie. We know employers, including state agencies, are required to provide reasonable accommodations for individuals with disabilities to apply for, compete for, and perform jobs. We've also talked about when a reasonable accommodation must be considered to meet qualification standards and reduce direct threat. Now let's talk about the importance of a reasonable accommodation statement, along with some examples related to the hiring process.
Sure, Dustin. Often individuals with disabilities do not need accommodations to compete for or perform the job, but when they do, you want them to feel comfortable to ask for what they need. Including a reasonable accommodation statement in the invitation to an interview communicates to a candidate that you are a disability inclusive employer who cares about what they need. This statement communicates the right to reasonable accommodation and informs candidates of who to contact if they wish to make a request. So for supervisors involved in the hiring process, it's a great idea to remember to include the reasonable accommodation statement in the invitation for the interview. We've included an example of a statement in the learner's guide. And to help candidates know whether they need an accommodation, it's also helpful to include information about the interview, such as a description of the virtual platform being used or the on-site environment. Also, whether the interview is video-based or panel style, and include a description of any tests being given, such as demonstrations or computer-based exams.
Julie, what are some examples of reasonable accommodations used in the hiring process?
Well, when a candidate with a disability needs a reasonable accommodation, what they need is determined on a case-by-case basis. However, I'll share a few general examples with you now. One accommodation may be to provide written information in an alternative format, such as large print or audio. Another is to provide a scribe to assist with completing forms or taking notes. You may be asked to provide a sign language interpreter or to permit the use of a service animal. And you may be asked to permit additional time for the interview to enable the candidate to process a question and then respond. It's important during the hiring process for the supervisor to know how to recognize a request for an accommodation and that confidentiality rules apply when someone discloses a disability and requests an accommodation.
And we will discuss both topics shortly in the next section, which focuses on the interactive process. Julie, what is the interactive process and what is the supervisor's role?
Dustin, the interactive process is the phrase the ADA uses to describe the informal and collaborative process that employers engage in when they receive a request for an accommodation. This includes state agencies, boards, and commissions under the governor's authority. The process includes the employer and the employee working together to identify and implement an effective solution. For most employers, this is a responsibility of the HR department. However, supervisors have a role in certain parts of the process, and so we are going to discuss recognizing a request, helping to identify a solution, being a part of the implementation, and monitoring the ongoing effectiveness of the reasonable accommodation. And we will address confidentiality too.
Well, since the process is initiated by a request, let's start there. Julie, why does a supervisor need to know how to recognize a request for a reasonable accommodation?
Justin, a research study from Cornell University says employees are 60% more likely to disclose their disability to a supervisor than to someone in HR. This is important to know because the employee may also request an accommodation with that disclosure. Based on this, and because a request for an accommodation may be subtle, it's helpful for supervisors to know how to recognize a request so it isn't accidentally overlooked. Here's what the EEOC criteria says about a request for an accommodation. The individual must communicate to the employer that a work-related change or adjustment is needed related to a disability or a medical condition. The request can be made in the individual's preferred form of communication, such as in writing or through a phone call. The request can use plain language, which means the request is not required to reference the ADA, Title I, or the term reasonable accommodation. And a request can be made at any point in the hiring process or during employment, including a performance review, which we will talk about later. So when an employee mentions to a supervisor a barrier to their work or requests a change at work and relates these to a disability or a medical condition, the supervisor has just received a request for a reasonable accommodation. I have a few examples to share. An employee tells her supervisor, "I'm having trouble getting to work at my scheduled starting time because of medical treatments I'm undergoing." This is a request for a reasonable accommodation. An employee tells his supervisor, "I need 6 weeks off to get treatment for a back problem." This is a request for a reasonable accommodation. A new employee who uses a wheelchair informs the employer that her wheelchair cannot fit under the desk in her office. This is a request for reasonable accommodation. An employee tells his supervisor that he would like a new chair because his present one is uncomfortable. Although this is a request for a change at work, his statement is insufficient to put the employer on notice that he is requesting reasonable accommodation. He does not link his need for the new chair with a medical condition. In addition to recognizing a request, it's also important for supervisors to know what steps to take when they receive a request. This often includes knowing who to refer the employee to in HR, so HR can continue with the interactive process. Also, it may not always be clear to the supervisor whether a person is requesting an accommodation, so it's a good idea for supervisors to talk with the professionals in their organization who are responsible for the interactive process to understand what they can ask the employee to clarify what is needed and why.
Knowing how to recognize a request is a great place to start. Now, although HR is usually responsible for the interactive process, there are times when HR may coordinate with supervisors.
That's correct, Dustin. HR may need to talk with supervisors to help identify an effective solution or to implement the solution correctly, and then to monitor the accommodation for effectiveness.
Great. So let's discuss how a supervisor can help identify a solution.
Justin, sometimes what an employee needs will be easy to determine, but when it's not, a supervisor can help support HR during the interactive process by consulting the job description, describing the essential functions, explaining the expectations of the job, and discussing any performance concerns. The supervisor may share what has already been done to help the employee, like providing additional training or a mentor, and the supervisor may also help suggest ideas. This is another reason why it's important to write essential functions based on the outcome of a task rather than on the way the task is usually performed, because it can be helpful in identifying an effective reasonable accommodation. Because remember, there is often more than one way to get the job done. So it's helpful for supervisors to be open to new ideas so they can take an active and helpful role in identifying a solution when needed. It's also helpful to know the various types of reasonable accommodations organized by the EEOC, like making the work environment accessible, restructuring a job, permitting a flexible schedule, altering or providing equipment and services, modifying policies, and providing reassignment. And being familiar with examples of accommodations can increase awareness of the many possibilities that exist. For example, an accommodation could be to provide a smartphone for an employee who is deaf to receive and send text messages, or to restructure a job by swapping the marginal functions of that job between coworkers, or providing a stand magnifier to enable an employee with low vision to read printed documents.
There really are many possibilities, and I think once you know that, it becomes easier to imagine how a job can be performed just as effectively in another way. The next step is to make sure reasonable accommodations are implemented properly. Julie, what is the supervisor's role in this part of the process?
Well, although supervisors are not permitted to know the confidential information about the employee's disability and the need for the accommodation, they are permitted to know what is necessary about the accommodation to make sure it is implemented successfully. So I have some examples. If a reasonable accommodation involves equipment, the supervisor may need to know when the equipment will be installed and if training is being provided. Because this might impact an employee's workday, the supervisor may have to make adjustments. When a reasonable accommodation includes a schedule change, for example, an employee who is permitted to leave work early once a week for 12 weeks, the supervisor would certainly need to know so they don't discipline the employee for leaving work, and also to make sure there is coverage for productivity or customer service needs. It's important for a supervisor to know when a policy is being modified as a form of reasonable accommodation, so an employee is not disciplined for misconduct. For example, a no food at the workstation policy may be modified so an employee can take medicine as needed with food. When outside services are provided as a form of reasonable accommodation, such as for American Sign Language interpretation, the supervisor may assist in ensuring the service is provided on time and effectively. Supervisors may also support implementing a reasonable accommodation simply by making sure the necessary steps are completed on time, or by communicating with the technicians who are installing the equipment, or by checking to make sure the accommodation is effective once it's implemented. It's important for a supervisor to know how they can support HR in the implementation process so they understand their role and so the accommodation is integrated smoothly into the workflow.
Julie, it seems there are many times that it is beneficial for the supervisor to be involved in facilitating the accommodation or to be made aware of the presence of the accommodation. What is the supervisor's role in making sure the reasonable accommodation remains effective?
Well, Dustin, first, it's important to know accommodations can stop being effective for a variety of reasons. For example, an employee's disability may change, and this could impact whether a different accommodation or an additional accommodation is needed. Or things can change at work with the job's essential functions, the equipment being used, the layout of the environment, or there could be a change in supervisor. Any of these can impact the effectiveness of a reasonable accommodation, so it's important to monitor the accommodations you have implemented. Now, someone in HR might do this, but some employers may have the supervisor monitor the accommodation. And so it's important for the supervisor to know if they have a role, and if they do, how HR prefers they monitor the accommodation, and who is responsible to advise the employee that someone will be checking on the effectiveness of the accommodation periodically. It's also a good idea for the employee to be informed of who to contact if an accommodation stops being effective, so this can be addressed before it impacts work performance or safety.
Monitoring an accommodation sounds just as important as the other steps in the process because we certainly know that things can change. You mentioned a change in supervisors can also impact the effectiveness of the accommodation.
Yes, there can be times when a change of supervisor has a negative impact on the effectiveness of a reasonable accommodation. Now, this may occur because a new supervisor changes or removes the reasonable accommodation simply because they are not aware the employee is receiving a reasonable accommodation. This can happen when the previous supervisor implemented an accommodation without involving HR and the interactive process, so it's not documented for the new supervisor to be aware of. And maybe this worked well for the employee and the supervisor at the time, but the interactive process should always be followed to protect both the employee and the employer. So this is another reason it's important for supervisors, including new supervisors, to be aware of their role in the interactive process, including how to document accommodations. Also, HR should make sure to notify new supervisors of the reasonable accommodations the employees they supervise are using when appropriate, so these employees continue to have what they need to perform their jobs when a change of supervisor occurs.
Sounds like making sure supervisors know to follow the interactive process is key. We've addressed many ways supervisors are involved, so let's discuss confidentiality because there are important criteria for supervisors to know.
Dustin, you are correct. There are confidentiality rules that apply to the disclosure of a disability and reasonable accommodations, and it's important for supervisors to know these. So the personal and medical information received must be kept confidential, which includes the information you receive at any point in the process, from the request for an accommodation through its implementation. The EEOC specifically says this disability-related information must be kept in separate medical files that are stored apart from general personnel files. And the EEOC indicates when certain information can be shared with designated parties. For example, employees who facilitate reasonable accommodations for safety purposes or during an emergency may know necessary information to implement these accommodations effectively. And as we mentioned, supervisors can know the necessary information for assisting with implementing a reasonable accommodation successfully. You just want to make sure not to share the confidential information about the employee's disability. For example, a supervisor may need to know about an accommodation, such as a modification to a break schedule. However, the supervisor is not permitted to know the medical information behind the need for the accommodation.
Julie, supervisors sometimes receive questions from other employees about the accommodations they notice in the work environment. How can an employer help supervisors understand how to respond to these questions without compromising confidentiality?
Justin, because the ADA prohibits employers from disclosing an employee's disability, the supervisor cannot tell the employee their colleague has a disability or is receiving a reasonable accommodation. The term reasonable accommodation is an ADA term. And so telling another employee that a colleague is receiving a reasonable accommodation would automatically disclose the employee has a disability, which is not permitted. The best practice is for supervisors to know the confidentiality guidelines and be informed of how their organization prefers they respond, because they will be asked these kinds of questions. The EEOC provides ideas for how to respond, so employers can review these to customize a response unique to their workplace. For example, a response could emphasize it's the organization's policy to assist employees who encounter difficulties at work. Or it could be explained that these types of situations are personal and it's the organization's policy to follow confidentiality guidelines. And it could be helpful to reassure the employee that his or her privacy would be respected in a similar situation.
This is good information for supervisors because they may feel caught off guard when an employee asks about a colleague's reasonable accommodation, and this helps them feel prepared to respond. Now, in general, supervisors manage employees with disabilities the same way they manage all employees. But there are some common workplace situations that can occur, and when they do, supervisors aren't always sure how to handle the situation when a disability is involved.
Dustin, you are right, and these include situations like performance, conduct, and safety.
Most of the questions that we receive are about performance, so let's start there. Just as a review, to be considered qualified under the ADA, an individual with a disability must meet the job's qualification standards that are job-related and consistent with business necessity, and be able to perform the essential functions of the job with or without a reasonable accommodation.
Right, Dustin. So based on this, supervisors can expect all employees, including employees with disabilities, to be qualified to perform the job's essential functions. Part of the supervisor's role is to manage performance, which includes addressing low performance. This is important to do because if you fail to discuss this with an employee, you put them at a disadvantage to improve their performance, or to request a reasonable accommodation if that is what is needed to enable them to meet the job's expectations. Now, an employee's disability often does not impact the ability to meet performance expectations, but when it does, a low performance review may be the first indication to the employee that their disability is contributing.
Julie, so what does the supervisor do when an employee realizes a disability is contributing to low performance and discloses their disability during a performance review?
Because the employee disclosed a disability, you don't want to overlook that, but you don't want your questions to be about the details of the disability. You want to ask the employee in what way the disability is impacting job performance. So best practice is to focus the conversation on the job and not the disability. The supervisor could do this by clearly communicating the job's performance expectations, the low performance problem, and ways to improve performance.
So the focus of the question related to the disability is on performing the job. Julie, what does the supervisor do if the employee asks for a reasonable accommodation?
When an employee responds to a low performance review by disclosing a disability and requesting a reasonable accommodation, the supervisor should follow the organization's procedures and refer the employee to the designated HR contact to begin the interactive process right away. This is another example of why it's important for supervisors to know how to recognize a request.
And what does the supervisor do if the employee discloses a disability but does not request a reasonable accommodation?
Justin, if the employee does not ask for a reasonable accommodation, the supervisor may ask what they can do to help the employee meet the performance expectations. Because the employee disclosed a disability, the supervisor can ask if the employee is requesting a reasonable accommodation. If the employee tells the supervisor what would help or would like to explore ideas, the supervisor should refer the employee to the appropriate HR contact to begin the interactive process as they would any request for a reasonable accommodation. If the employee declines help, the supervisor should provide the employee with information of who to contact if they decide to pursue options another time.
Julie, a great question we receive often is, what should a supervisor do if they think an employee has a disability that is contributing to low performance, but the employee has not disclosed a disability or requested an accommodation?
Well, in general, the supervisor should focus their questions on the employee's job performance by clearly explaining what performance measure is not being met and what the expectation is. A best practice is to ask the employee what you can do to help them meet the performance expectation without mentioning disability, because it is generally preferred that discussing disability be initiated by the employee.
Sounds like it's a good idea, a good practice for supervisors to focus their questions on the job and ask the employee what they can do to help them meet the job's expectations. What about the consequences of low performance? Do these apply to an employee with a disability?
It can, Dustin. Reasonable accommodation is prospective, which means it is future oriented. And so when an employee responds to a low performance rating by disclosing a disability and requesting a reasonable accommodation, the interactive process should begin promptly, but the employer is also permitted to apply the consequences that apply to any employee with low performance in the same job class. Now, some employers may choose to wait to apply a consequence, such as a performance improvement plan, until the reasonable accommodation is implemented, to give the employee an equal opportunity to improve performance. For example, if the accommodation is to provide additional training, it could be best to pause the improvement plan until the training is complete. The obligation for the employer to provide a reasonable accommodation does not require employers to accept low performance, withhold consequences for low performance, raise a performance rating, or assign a rating that does not reflect actual performance.
Okay, so the consequences apply, but a reasonable accommodation must also be considered when it's requested. Let's talk now about conduct. Employers are generally permitted under the ADA to create conduct rules and consequences for misconduct. And employers can expect all employees, including employees with disabilities, to follow these rules. Conduct rules are things like prohibiting violence and stealing and requiring employees to treat coworkers and customers with respect. Julie, what happens when an employee with a disability violates a conduct rule and disability is not a factor?
In this case, Dustin, the employee may be disciplined with the same consequences that would apply to any employee who violates the same conduct rule. Now, often employees with disabilities do not need reasonable accommodations to meet conduct standards, but when an employee's disability does contribute to misconduct, a reasonable accommodation may enable the employee to meet the conduct standard effectively. As we said before, reasonable accommodation is prospective, and so just like with performance, the employer's obligation to provide reasonable accommodation does not require a supervisor to excuse misconduct or withhold consequences when an employee indicates a disability contributed. However, when a conduct rule is applied to an employee with a disability, the conduct rule must be job-related and consistent with business necessity, and this rule must be equally applied to all employees. Determining whether a conduct rule is job-related and consistent with business necessity is based on considering criteria like the disability-related symptom that is contributing to the misconduct, the frequency of the symptom, the nature of the job, the specific misconduct, and the work environment.
Julie, this seems critical to consider when the misconduct is related to a rule that is ambiguous, like disruptive behavior, because what is considered unacceptable may be unclear.
You are right, Dustin. So to help explain this, I'm going to summarize an example from the EEOC about the same employee with the same disability in 3 different situations. Steve has Tourette syndrome, which is characterized by involuntary, rapid, sudden movements or vocalizations that occur repeatedly. In the first scenario, Steve works as a teller at a bank, and his behaviors have caused several customer complaints and are distracting his coworkers. Because Steve's behavior causes him to not be able to perform the essential function of serving customers, and because his behaviors are unduly disruptive to his coworkers, Steve is eventually terminated according to his employer's disciplinary procedures. The EEO states in this example that termination is permissible because it is job-related and consistent with business necessity to require tellers be able to conduct themselves in an appropriate manner when serving customers and refrain from interfering with the ability of coworkers to perform their jobs. In the second scenario, Steve works as a teller at a bank, but his behaviors are infrequent and do not interfere with providing customer service and are not disruptive to his coworkers. Now, terminating Steve would be a violation of the ADA because it is not job-related and consistent with business necessity to require Steve refrain from these minor behaviors that do not interfere with his coworkers doing their jobs or with his delivery of appropriate customer service. In the third scenario, Steve works in a noisy environment and does not interact with customers and does not work near his coworkers. His behaviors do not distract his coworkers. In this scenario, Steve's behavior is not causing him to be unqualified for his job or to be violating the conduct rule of disruptive behavior. So this example illustrates what to consider to make sure a rule like disruptive behavior is applied appropriately and not in a way that discriminates against employees with disabilities. Now, this example did not mention the interactive process or reasonable accommodation, so just remember during a discussion about misconduct, if the employee discloses a disability, the supervisor should know what questions they are permitted to ask to determine if the employee is requesting a reasonable accommodation and what questions they can ask to determine how they can help the employee meet the conduct standard in the future. If the employee requests a reasonable accommodation, the interactive process should begin, just like we discussed with addressing low performance.
Okay, before we conclude, let's discuss safety. Employers are permitted under Title I to require applicants and employees not pose a direct threat to health and safety in the workplace. Julie, what is a direct threat?
Dustin, the EEOC defines direct threat as a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. The direct threat standard must apply to all applicants and employees in a specific job class. And if it screens out or excludes an individual with a disability, The standard must be job-related and consistent with business necessity, and reasonable accommodation must be considered. It's important to know that direct threat must not be based on a myth or a stereotype or based on an opinion or an assumption that someone may not be safe to perform a task. Direct threat must be based on an individualized assessment that includes objective evidence about a particular individual's current ability to perform the job's essential functions. I have an example from the EEOC that includes making an assumption about direct threat. Let's say you are interviewing a candidate for a position working in a laboratory and he discloses having cerebral palsy, which limits his manual dexterity. You can't assume the candidate will be at risk of breaking glass containers filled with dangerous chemicals. You must conduct an individualized assessment to determine whether a direct threat exists.
Julie, what is the role of reasonable accommodation in direct threat?
Justin, when the individualized assessment results in a direct threat, the employer must consider whether there is a reasonable accommodation which can eliminate or reduce the risk to an acceptable level.
Thank you, Julie. That brings us to the end of our discussion in this webinar. So would you like to share some final thoughts before we close?
Yes, thank you, Dustin. Supervisors have a key role in making sure qualified candidates are hired, reasonable accommodation requests are recognized, and effective reasonable accommodations are implemented. We hope the information we shared today provides supervisors with the strategies they need to feel comfortable when hiring and managing employees with disabilities. Thank you all for your interest in this webinar.